And the ramifications for business are enormous because business will then be expected to achieve equality of outcomes as between the poor and the better off. And that's an extraordinary obligation to place on business.
The PEPUDA Amendment Bill poses a significant risk to businesses in South Africa. If passed, this proposed legislation would require business owners to enforce strict equality of outcomes in their organizations. Joining me to discuss the risks emerging from this legislation is Dr. Anthea Jeffery of the Institute of Race Relations. She recently submitted on behalf of the IRR a comment to the Department of Justice and Constitutional Development on this bill. Anthea, welcome to the CRA channel. Could you tell our viewers what is the risk specifically for businesses arising from this proposed legislation?
The main risk to my mind in an altogether very controversial bill deals with its provisions on equality, because they require businesses to achieve an equality of outcome, which is impossible in practice, and yet businesses that fail to achieve it could be penalized quite severely, though we don't know quite how badly. And the bill is an amendment to an act, the Promotion of Equality and Prevention of Unfair Discrimination Act, that was adopted in 2000. At that point, its equality provisions were evaluated by the National Treasury in a regulatory impact analysis, and the Treasury warned that they would place an unconscionable burden on business and also on the state. And so those equality provisions were never brought into operation. But now, despite the fact that our economy is reeling from the COVID lockdown and from a number of damaging interventions over many years, the department now plans to expand the equality provisions and to bring them into operation. And what is particularly damaging about these equality provisions is that they do, as I said, require business to achieve equality in terms of impact and outcomes, and also to make sure that they are providing equal access to resources, benefits, opportunities, etc. And this must be done on all of the 18 grounds of discrimination, potential discrimination, which are listed in the Act. They include, the ones that we're familiar with: race, gender, disability, age, and so on. But the Act also makes it possible for the equality courts that it establishes to recognize poverty as an additional ground of unfair discrimination, comparable to racism and these other listed grounds. And we already have in the Western Cape High Court, sitting as an equality court in December 2018, a judgment recognizing poverty as a prohibited ground. That judgment was handed down in a context of policing rather than in a business sphere, but another equality court might already take the view that we do already have poverty as a recognized ground.
Enjoying this analysis? Click here to sign up for our 30-day free trial for more content from the CIA.
Anthea, that's very concerning. What are some of the practical effects of these changes? How might this affect specific business sectors?
The ramifications for business are enormous because business will then be expected to achieve equality of outcomes as between the poor and the better off. And that's an extraordinary obligation to place on business. If one thinks just of the banks, they have an obligation, of course, to safeguard depositors' savings. But if they now come also under an obligation to achieve equality of impact and outcomes between the poor and the better off, that might push them, that might put them under pressure to extend mortgage bonds, for example, to people who can't really afford them. And we know that this is what happened in the global financial crisis in 2007-08, what underpinned that crisis. And the upshot, regrettably, was that millions of people in the US actually lost their homes. And they also, many of them lost savings because the banks were in so much trouble. The entire economy was in so much trouble. And we're faced really a risk where, as business tries to achieve equality of outcomes between the poor and the better off, they obviously must drop their prices, but business can't survive unless its earnings exceed its expenditure. So we face the risk that many businesses might at the least have to retrench, that some of them might in fact go bankrupt under this kind of pressure. And yet the Department of Justice and a number of proponents of the bill seem unconcerned about this potential consequence of the bill, and they decline to take it into account. They prefer to think that this will achieve equality in a real way in the real world, when unfortunately that is most unlikely to happen. And of course, if you're really going to help the 11.4 million people who are unemployed, what we need is investment and growth and many more jobs, not measures that will put business under so much pressure that increasingly they will have to retrench or even go out of business. And that seems to me a risk that must be flagged very heavily. This is the aim of our issue alert, to show how the obligation to attain equality of outcome could affect businesses in many spheres, in banking, in insurance, in the pension industry, for retail business in general, and of course also in other spheres like healthcare or education. The potential is actually enormous. It's so wide-ranging that one hardly can begin to tell just how far it could extend.
So, Anthea, it seems that there's an inconsistency emerging here between this proposed legislation and also what the Constitution says about equality. Do you want to speak to that tension that's emerging?
Yes, indeed. It's important to remember what the Equality Clause says. And it first of all prohibits, or rather requires, equality before the law, because, of course, during the apartheid era, that was denied to Black people. They were discriminated against under statutes that barred them from buying land or houses, for example. Equality before the law is vital, and it's something that must be upheld. Secondly, the Constitution makes provision for equality of opportunity through its affirmative action provisions, which are intended to make it easier for the disadvantaged to get ahead. We have many flaws in the way those laws work, but that's the idea, that through equality of opportunity, measures can be taken that will help the disadvantaged to get ahead. And then there's the notion of equality of outcome. And that is something which simply cannot be obtained in the real world and which our Constitution does not endorse. And yet the bill tries to pretend that this is required by the Constitution and therefore that what it says is constitutional when this is not so. And it fails to recognize that the pursuit of equality of outcome will undermine equality before the law because people will have to be very differently treated. And it will also undermine equality of opportunity because the likely effect will unfortunately be to weaken our economy, increase unemployment, and reduce the opportunities that are available.
Anthea, you recently made a submission or a comment to the Department of Justice highlighting some of the concerns with this legislation. Could you tell us what is the process from here? How do you see this process playing out?
Well, the Department of Justice must now, of course, evaluate the written submissions that it received. This is such a complex and difficult law to understand that it's not clear how many people did get involved in the commenting process. They ought also already to have commissioned a comprehensive socioeconomic impact assessment so that the kinds of risks that I've been highlighting can be properly evaluated. They ought also to be making available to everyone the Treasury's regulatory impact analysis of the equality provisions as they are now, the original equality provisions, and the Treasury's warning that this would pose far too heavy a burden on business and incidentally also on the state. And then people would be better equipped really to understand what is at stake. The department must take all the written submissions, all the risks and relevant factors into account, and one must hope that it will then draw back. But if it decides to proceed in any event, then the Portfolio Committee dealing with justice and constitutional development of the National Assembly will then put out a further request for public comments, and the bill will go through Parliament in the normal way. But one must hope that enough opposition can be mobilized now to stop that from ever happening.
Anthea Jeffery, thank you very much for joining us again on the CRA channel. If you would like to know more about the practical effects of the PEPUDA Amendment Bill, you might want to check out this video over here. That's an interview with Advocate Mark Oppenheimer of the Johannesburg Bar. Also, please do feel free to get in touch with me directly if you would like to talk about the work of the CRA and any of the content that we present here. I've put a link to my LinkedIn profile in the description below. You can get in touch with me that way. When you connect with me, just mention that you saw one of our videos. That's it from me, David Ansara. Until next time, take care.